Okay, hello and welcome everybody to this new installment of Karger in Conversation. I am Francesca Brazzarotto, Customer Engagement Manager at Karger and organizer of this event. For those of you who haven't attended before, this series is a quarterly event that brings together experts from the publishing industry, librarians, information and tech specialists, funders, and researchers worldwide. The main aim is to discuss the latest trends and topics in scholarly publishing from all perspectives globally. So you should see a link on the screen to our page where you can find recordings of our previous events and panels and stay updated for future events. Please save it for future reference. So today's panel discussion will focus on the often overlooked challenges of AI in scholarly publishing. While many events highlight the endless possibilities of AI tools, which indeed enhance work and research efficiency, we aim to shed some light on the significant ethical, technical, and legal challenges they also pose. We have three experts from the legal, tech, and library sectors who will examine the complexities of using large language models in creating and utilizing scholarly materials. They will touch on topics such as bias, responsibility, ambiguous copyright boundaries, and potential ethical violations. Please be aware, our goal today is not to discourage the use of AI, not by any means, but rather equip you, whether you are a researcher, a librarian, an academic, or a clinician, with the knowledge and tools to navigate these challenges effectively. So before we dive in, let me introduce our experts today. So we have Siobhan Jaime, who's a publishing technologies librarian at the Open Library of Humanities, based at Birkbeck College, University of London. She supports Diamond Open Access Publishing and the development of the Genoway open source publishing platform. With a BA in liberal arts and sciences, majoring in computer science, neuroscience, and linguistics, Siobhan is passionate about knowledge equity, open education, and AI ethics, particularly around data governance. Welcome, Siobhan. Our next speaker is Christine Stone, the Senior Director of Strategy and Innovation at Clarivate, where she leverages generative AI to enhance academic content, discovery, and engagement. With a strong background in library science, information systems, and history, she's dedicated to lifelong learning and community engagement. Christine has co-chaired NISO's Information Discovery and Interchange Topic Committee and currently serves on the Crossref board. Welcome, Christine. And then our third speaker is Jonathan Bend, an American lawyer specializing in intellectual property and internet law. He has played a key role in shaping laws like the Digital Millennium Copyright Act and the Stop Online Piracy Act, and has extensive experience as counsel to the Library Copyright Alliance, also known as LCA, which consists of the Association of Research Libraries and the American Library Association. Jonathan is also an adjunct professor at Georgetown University Law Center and has authored several books on intellectual property. Welcome, Jonathan. Thanks for being here. So finally, a bit of housekeeping. This event will be recorded and made available to you with English subtitles. With almost 500 people registered from across the globe, we want to ensure that those who couldn't attend today or can only partially attend can watch it later at their own convenience. Feel free to drop any questions in the chat or the question box on your screen, and we will monitor them and address them to our panelists at the very end of the event. Lastly, you also see a screen at the end of the panel discussion, and we also receive an email from us today allowing you to share your feedback. You will be able to advise us on topics that you'd like us to cover next time, and let us know if you would like to be one of our speakers. Don't be shy. If there's a topic that you think could be of interest and you could speak on it, let us know. And now I will leave you to our panel moderators, Karger's Head of Academic and Research Markets, Chris Fox. Let's spark the conversation that define our industry future. Chris, over to you.
Okay, great. Thanks very much, Fran. From my side, thanks very much for everyone for joining, and thanks to our panelists for agreeing to be part of the conversation today. This is a really interesting topic. I guess it's in some ways the topic at the moment, and most of us will have spent many hours thinking about large language models and perhaps listened to many webinars about what the implications might be. You know, from my experience, that lots of them have been about, as Fran described, what the hopes of what it might be able to deliver, or perhaps some of the fears that it might have of impacts on our day-to-day lives. But we'll all agree that they're going to be an increasingly important part of our lives over the next few years. And so it's really important that we think about the practical implications, both in everyday society, But I think for us today, thinking specifically about scholarly communications and scholarly publishing and what some of the implications might be there. So really looking forward to discussing today. I think it's always interesting and useful to start these sessions with some definitions and just to kind of frame the conversation a bit. So I'd really like to start with just a very fundamental point. Christine, I wonder if we could come to you first, and maybe you might just say, for the benefit of our listeners, particularly those that might be not so familiar with the topic, what do we mean when we say AI? What do we mean when we say large language models? And perhaps you might just illustrate with 2 or 3 examples of where that might be relevant in scholarly publishing and scholarly communications kind of now or in the near future.
Okay, so yeah, I'd start this off. It's a little bit hard to explain in just 2 minutes what LLMs are and AI is. I think generally speaking, we talk about AI and today we really kind of mean large language models, but AI has been around for a very long time. And I think many of us work with different tools, specifically machine learning tools in different capacities for a long time. We're using them usually for very specific tasks. But now we have large language models. Everybody knows about ChatGPT. How does this work? So large language models are trained on a huge amount of data to predict basically in a sentence or in a text the next token. I kind of like to compare this with learning a foreign language. Just imagine you don't speak French and you want to learn French. You learn the vocabulary, you learn the grammar, you get some feedback from your teacher or from other people, you learn to construct sentences, etc. And after a while, you start just talking and your brain automatically calculates what the next word is in a sentence. And that works very similar in a large language model. It basically automatically calculates what is the next word in a sentence based on the data it's being trained on. So very simplified way to explain that. You asked for a few examples. I mean, there are many ways where large language model can be used. They're very good in working over a vast amount of data and creating coherent text, also creating coherent questions and that sort of thing. You can use it, for example, for efficiency. That's for peer review processes, identify reviewers would be an example, but also for quality assurance, raising red flags. For example, we are using it in a library context, also for discovery, for supporting natural language search, for creating, for example, answers or for creating insights from documents. That could also be a use case. So there are a number really of use cases here that are important. I think there are great opportunities here, but we are also talking about the challenges, and that's certainly also to do with, there's the machine doing something and here is the human sitting and doing something. So one of the things that I would say here, and I'll repeat this maybe also later, is that human in the loop is an important aspect also in large language models and with using large language models in our technologies.
Mm-hmm. Great, thanks. I think that's a nice definition. Anyone that can describe that in 2-3 minutes is doing pretty well. So that helps us, I think, to get started. So, Jonathan, maybe we might come to you next. And maybe I wonder if you might be able to describe just at a very broad level how advanced you think the legal frameworks are around thinking about large language models and scholarly communications at the moment. And maybe you might be able to just introduce what perhaps you might see are the 2 to 3 critical kind of legal questions which exist at the moment that we could delve into in a bit more detail throughout the conversation.
Sure, thank you. And thank you for having me here. As Christine just said, AI is not new. It's been around for at least 20 years in one form or another. What's new, of course, is the large language models and generative artificial intelligence. But sort of AI as a tool has been around for a long time, and we all use it, right, all the time. Spell check, grammar check. We've had it for a long time, and we know it's good and it's bad. It has advantages, its strengths and weaknesses. So in terms of the legal issues, there really are 3. So one is, as Christine mentioned, to train the large language model, you need to have a huge training data set. And typically that is created by crawling the internet, or just gathering huge amounts of information and ingesting them into all that information into a training data set. And that act of copying could be an infringement. And so that's the first question. Is all that ingestion of typically copyrighted information, whether it's photographs or songs or movies or text, is that ingestion infringing? The second issue is on the output side, whether whether the output of the large language model, after the user has his prompts or her prompts, there's output, and let's say it's text or image. Does that text or image, does that infringe on the copyright of any existing material? Typically any material that may have been ingested. So that's the second issue, and there's lots of complications and wrinkles with that too. And then the third issue is, if you, again, focusing on the output, let's say I use AI to create something, again, an image, or in this, let's say a scholarly article, can I now receive copyright protection in what I've created using the LLM, or am I somehow not eligible for copyright protection by virtue of using the tool? And the added layer of complication, in addition to the fact that you have these three very distinct questions, is that we're working in a global environment, and the legal framework is different. What works, or what the rules in the U.S. Might be different from what they are in the EU and in the UK, which might be, again, different from what you have in the Far East. So that's just an added layer of complication here.
Okay, great. Maybe just for interest, to try and understand how advanced that is as well. I mean, if you had to try and put on a scale of 1 to 10 how kind of ugly the problem is from a legal perspective at the moment, where on 1 might be it's just new and we haven't kind of resolved it yet, to 10 where there seem to be things that are completely unresolvable. I mean, where would you sort of put the scale of the issue at the moment?
Well, that's an interesting question. There is a lot of litigation in the United States. Now, we're a very litigious society, right? So, there's lots of lawsuits, and the fact that we have lots of cases doesn't necessarily mean that much, but there is a lot of litigation. I would say that overall, it's probably a 4, because we do have a lot of cases. I think a lot of the issues on the ingestion side will shake out pretty clearly. I mean, there's always a chance that courts will start finding these LLMs or the ingestion to be infringing. I think it shouldn't be infringing in most cases, but in some cases it might be. So I think that that will be resolved relatively smoothly. In the EU, to a large extent, the ingestion issues have been resolved. Same with Japan and Singapore. They've legislation. With respect to the output side, that's going to be a mess, but that's because copyright issues relating to that sort of thing are always a mess. It's not, those issues are not unique to generative AI. Someone creates a work that's similar but not identical to your work, or it's in the same style as your work, or Christine took that beautiful photograph that's behind her, but if another photographer came along and said, "Ooh, that's my photograph," or "I took something very similar to that," right? I mean, those issues have been around forever, and they're still going to be around, and that's nothing. That issue is really not a new issue. And then the third issue will also get resolved. I think it's simply going to be a question of, in different jurisdictions, they're going to have require a different level of human involvement. in order to receive copper. But I think all of these are resolvable. It's just that it's going to take, at least in the US, a little bit of time because we do have all of these cases.
Okay, great. Okay, so glad to hear it's not a 10 at least, and there are some progress that we can make there. I really like to try and frame the ethical side a little as well. Perhaps this is one of the more difficult things to frame, but I find that quote useful that says, ethical behavior is doing the right thing when no one else is watching, even when doing the wrong thing is legal. Siobhan, I wonder if we might be able to ask you to help us just define, in your experience of working with researchers, how well you think the ethics and the ethical boundaries are, how well defined they are in terms of using large language models in the realm of scholarly communications. And feel free, if you like, to highlight 2 or 3 of the kind of key areas from that perspective as well that you think might be useful.
I think that largely we are still in the process of figuring that out, because as quite infamous, public sector work can be slightly behind the public because we have to wait on, say, the legal sides to make certain decisions. And this will obviously also depend on the territory you're in, the organization you're in, like how far ahead is the organization that you work in, have they given this thought or are they waiting? So this can be quite contextual, but I think overall it is still quite fuzzy, because obviously whilst the legality is relatively easy to resolve, as we just heard, ethics are often not as easily resolved. And I think one thing to consider when we think about research and scholarly comms is there ever truly no one watching? Because our work needs to be transparent and reproducible as a base. That is, in many ways, that is what we do. So I would almost say there will always be someone watching, because if no one were watching, then what is the value of our work? Very frankly put, I think that we have to think about this issue in a much larger context, and I think it almost goes back to existing issues within scholarly communications when we think about publication pressure, when we think about job pressure and precarity, because ultimately what these tools do is that they are meant to make these processes faster and more efficient, but they do have the risk of exploitation, as every technology does. And it's kind of, I always argue as someone who's done computing that it is in human nature to see how far can we push the technologies, how far can we push the boundaries, because that is how we learn and innovate after all. But I think it is fuzzy, and I think we have to, not just when we think about ethics, we have to think also what drives people to do certain things. And I think we can't ignore things around publication pressures and existing pressures in the sector when we consider ethics. Because again, legality might be more black and white, but ethics is nice and grey in many of these ways. It isn't as much have you done something wrong, but why have you done something wrong, and that why is difficult. I think to give some examples, I think I have to start with the very infamous ones of certain papers that will start with, certainly I can give you an introduction to your topic, and we all go, that was generative AI, you haven't even bothered to edit it out, or kind of those telling phrases of, I can't do X, but I can do Y, and you can see that this was written by an AI. But I think it touches again on that sort of more systemic underlying issue of that pressure to publish, which tells you that someone has been put in a position to do this in the first place, has not checked their own work. No one at this journal has checked their work. Apparently there hasn't been budgeting for a copy editor, because I can almost guarantee that any half-decent copy editor would have picked up on that immediately. Why have these things not happened? And these things are usually economic, as is in many of these kind of problems. I think that's the first issue we have to consider, and I think the most infamous one. The second one in scholarly communications that is particularly relevant to us, I think, is stochastic plagiarism. So this is accidental plagiarism by the machine. And so effectively, if the machine would give you an output that is significantly copied from its training data or fine-tuning data, and it hasn't told you so, which means you as a user might be committing plagiarism through the machine. Now, technically speaking, the percentage of instances which has happened is relatively small. You often cite between 1 to 3%, most often 1%. But say you have 100 people who use the machine 2 to 3 times a day. That's not an awful lot. And they do this 5 times a week, because obviously they don't work 7 days. That gives you, what is it? So there's a total of 200, 300 uses a day. That is 2 to 3 times a day you might get stochastic plagiarism, which then gives you 10 to 15 a week. And that then goes to 40 to 60 instances a month if it's 1%. And now a lot of this will probably never reach the outside world, will never be published. But say even 1 or 2 of these get through, the implications of that can both financially and legally be quite prickly if you happen to have gotten the wrong thing there. But also ethically, that is problematic, because we have to be transparent and reliable, and citation is important, even if it isn't illegal to not cite and attribute the sources. The police isn't going to come to your house and say you haven't cited properly, you go to jail. But it is important when we think about research and what research represents and how we position ourselves within our community. And I think that is a challenge that we will have to think more about, most likely, and think about how do we deal with those risks and what are the ethics of this, and is that a risk that we want to take ethically, even if legally it's probably fine if you're not doing anything that is too outrageous. And I think similarly, two other tricky ethical issues are firstly around data analytics and any kind of analyzing of data, because there is no way that a system such as this can be unbiased. All of these systems will have bias. If you haven't found the bias in a system or a data set yet, doesn't mean there isn't one, you just haven't found it yet. That is bias. And the moment you are doing this at such a scale that it becomes really hard to control, and that we might be giving tools to people to do tasks they don't fully understand, we are introducing risk. I often say, when you are using a tool to automate a process, you need to be very certain that you as a person understand the process. So I would do it for transcription. I've also been trained to transcribe. I can find the errors, I know what to pay attention to. I might use it for statistics. I've been trained as a statistician. I can verify this myself. If I ask it to write code, I know what it is telling me. But say if you're not trained to do any of these things, so write code, for example, which is a more specialist skill, and an AI churns out code, are you able to verify its output? Can you find the errors? And when this is something sort of dry numerical like code, there might bias will still be there, but it's not as impactful. The moment you're asking it to do, say, a qualitative analysis, there might be bias and you might not be able to see it. And I think that poses an ethical issue, because these decisions and these reviews and these analyses, they can impact people, they can impact real human lives. And as we know in statistics, it is very easy to forget that these rows and rows of data that we might be looking at, they might each represent a person and someone's life. And we already have it in our current way of doing statistics when they become numbers. Now imagine you don't even see the numbers. You don't even see this massive spreadsheet. There might not be a point at, I don't know, 11 o'clock at night when you look at this spreadsheet and you realize these are all people. You'll never see this. And I think that is an ethical risk, because it further makes these decisions abstract, and especially in healthcare, that can be really impactful. And I think the third one, which is sort of a classic scholarly communications issue, it's peer review again, which it ties into the publication pressure. But I think there is a risk, and I'm not saying it will happen, that we might have articles written by machines that are not being assessed by other machines to be published, to be ingested by machines. So more machines can write more articles, and all of us go have a cocktail on the bar. Well, probably not that last part. I think that's wishful thinking on my behalf. But I think there's a risk there, and also we need to, beyond the ethical aspect of that, of can a machine review information? And I would argue it currently can't. We know that, at least in my experience, that these machines struggle to do quality control, especially if they are not very carefully fine-tuned and specialized. If something shifts ever so slightly or might be really new and innovative, machines tend to struggle with that. And we know you can manipulate machines quite easily as well. You can manipulate them to do what you want. You can, in the same way that you can manipulate a CV screening sort of piece of technology, which people often do when they apply for jobs, you can probably do the same with a peer review one if you do enough testing. Is that ethical? And obviously the current system has issues as well around bias, and especially foreign language speakers. But the moment this becomes less and less visible, transparent and controllable, I think we have a risk. And again, why are we outsourcing this work to a machine? Why are we under such pressure that this needs to happen? And I, as someone who peer reviews myself, I know it takes up time and it is quite an investment, and the system is in many ways tricky to navigate at times in terms of ethics and fairness. But I do think it is a meaningful activity as a researcher and someone active in a field to peer review and to be involved in research and to know what is happening and not just outsource this. Sometimes these tedious jobs can be really good for you and really meaningful. And we see the same in teaching, that transcription is, if you are a linguist, which I used to be, is very good to learn to do by hand before you outsource. And I think peer review is one of those. It might come off as tedious, but there is value in the work, and we have to think about why are we doing this? And again, what are the ethics of it, which is a bit broader than ethics, but I feel like they all come together, and to me, discussing one without the other doesn't make the most sense. I hope that wasn't too long. That's not quite 3 minutes, I think.
But that's good. But I mean, I think that already sets us up for some of the points which we were probably going to discuss later anyway. But I think what's interesting coming from all three of you there is, Christina, I think you used the phrase human in the loop, and Jonathan and Siobhan, I think what you're touching on there is that although the introduction of LLMs is a kind of radical step in some ways, it's still just an extension in some ways of what we do already, if you like, and so lots of those rules can still apply. And yeah, I think I'm right in saying this, but I might be wrong. I don't think an AI has ever come up with a scientific theory, for example, has it? And so all of that still exists at the core, and it's just how we might be able to implement it potentially to support some of the activities which we already carry on. But anyway, great. I think that was really good as a framing session. What we're going to do now, I'm going to try and move on and delve into one of the topics, or all of the topics, in a bit more detail. We're going to start with, I think, the first topic, which, Jonathan, you mentioned in the list of legal challenges, which is, let's call it the input problem here. You know, so this is this whole problem around how should or could scholarly communication works that are under some kind of copyright, whoever owns that copyright, I don't think that's relevant necessarily for today, be used in the training of LLMs. And maybe we come to the legal aspect first. Jonathan, you kind of touched on this a little bit already, explaining, you know, there's a kind of geographical difference, and you mentioned that some of it is perhaps already on a path to being resolved. Maybe you could just give us a bit more detail on that and describe what resolved looks like.
Sure. So let's start with the EU, and the UK has pretty much the same rules because they were developed or in development before Brexit. There are two exceptions in the directive on copyright in the digital single market on the directive on copyright in the single digital market. And what they allow is basically they allow reproduction for the purpose of text and data mining, and then there's sort of a definition of what that is. If it is done for purposes of non-commercial scientific research, and scientific is broadly defined, so it's not just the hard sciences. But then you fall within the scope of this exception. So that if now this typically would not apply, let's say, to an OpenAI, ChatGPT, right? I mean that's you know, even though OpenAI is technically a nonprofit, it has a lot of for-profit money, and it's in partnership with Microsoft, so it probably would not fall within Article 3 of the directive. But let's say if a university put together its own LLM, then it would likely fall within that exception. But then there's a separate exception that would apply to the Googles and Facebooks of the world, and presumably OpenAI as well, Article 4, which basically says you have this exception for allows you to basically make reproductions for purposes of text and data mining for commercial purposes, so long as the user has the opportunity to opt out. So it's an opt-out regime. Now, at least in the early days of generative AI, it was pretty, you know, first of all, no one, you know, you had the internet company, you know, the AI companies already ingesting before you had the directive, and so it was like, well, how do you go back in time? There was that problem. There was the related problem that, you know, if you wanted to opt out, how could you really opt out? Because if you the way that was envisioned is there is a way to opt out of search. If you don't want your website crawled by a search engine, you use what's called the robot.txt. It's a protocol, a little bit of code that then stops the spider from crawling your site. But the problem is that if you say, okay, I don't want to be crawled, then you're invisible. So let's say you want to be crawled for indexing purposes so that you can be included in the search index, but you don't want to be included for training purposes in the training database. So originally there was like no, you know, it was like all or nothing. but now Google and Microsoft both have refined their robot.txt so that you can set your bot exclusion header to say you can crawl my website for search purposes, but you can't ingest my material for AI training purposes. So now you really do have an effective way of opting out. And relatedly, with respect to the going back in time problem, it turns out that every new release of an LLM, they train it from scratch. Then this is a common misconception. I had it, that I thought that, you know, every release of an LLM sort of built on the previous LLM. And so if you had sort of infringing material or material that, you know, before a person opted out, there was no, you know, it was in there forever. And so that was going to be a big problem for these AI companies. But it turns out that every new release, you know, not every, you know, kind of slight improvement, but when they do a big release, they retrain from scratch, in which case they would, you know, if they're now respecting the opt-outs, and, you know, there are opt-outs where a person can, you know, say, you know, yes for indexing purposes, but no for training purposes, then you can imagine a world where you have a database that's pretty, you know, or an LLM that doesn't have everything that's only everything that was in the training set was agreed to by the rights holder. So that's the framework in Europe on the ingestion side. In the United States, we don't have any specific legislation. Instead, what we have is the fair use doctrine. And that's a judge-made four-factor analysis that was then codified, lots of case law. There are some precedents that would be informative. There was a case that the Authors Guild brought against Google. There was another case that the Authors Guild brought against HathiTrust. And those principles, those cases, those precedents would seem to indicate that the sort of the ingestion for training purposes, you could make a good argument that that should be fair use, but that's going to have to be sorted out by the courts, and that's the kind of thing, as you know, that's where we have all this litigation, and it will take a while, you know, because first you have the trial courts make a decision, then it goes up on appeal, and then it goes to the Supreme Court, and that can take 10 years to get sorted out, or more. And so I expect that will take a while. And you know, in the meantime, of course, the technology is going to evolve tremendously, even as the way I indicated, with the, you know, with the more granular bot exclusion headers. You know, from a fair use perspective, that a court could say, well, that makes a huge difference. I mean, if there is the opportunity to opt out and you didn't opt out, now you know, for you to be complaining now is, you know, that sort of cuts against the equities, because ultimately fair use, as the name implies, it's all about equity. So that's sort of how, you know, getting to the next level of where the legal issue is with respect to ingestion.
Okay, and I suppose that sort of suggests that we've got some clearer rules on what should and shouldn't be allowed. There's then the question of whether everyone is following those, which is not to do with the rules, but about whether they followed those rules or not. But I mean,
and relatedly, you know, so we're, you know, right now, you sort of like the best known and the largest companies are based in the U.S., but they're going to want to comply with the rules in the EU because they want to do business there. And under the Developing AI Act, they would have to comply with the Copyright Directive in order to do business in the EU. But of course, you know, you have, you know, there's other countries in the world, and in particular, you know, here in the United States, we have this obsession with China. And so, you know, we cannot, it's all very well and good. We talk about what we're doing, but, you know, what they're doing is, you know, we obviously have no control over.
Okay. One question I sort of wanted to ask is, maybe, I'm not sure it's quite an extension of that question, but one thing that's related to it and specific to scholarly, not specific to scholarly publishing, but something we think about particularly in the OA world is the relevance of CC licenses in all of that. I mean, I try to sometimes think about how CC licenses fit into the realm of large language models, and it kind of makes my head explode. I find it difficult to try and, you know, align the two. Perhaps, I don't know, Siobhan, maybe do we want to come to you first on that, and if you had any views on
yeah, it is a very heavy one, and it's something I've put a lot of thought into myself, and I think it's one that we have to almost do together with legal experts. I think that is one that we have to collaborate on. I think in my view, so I've a background in the UK and EU, which has a stricter like way of dealing with this than the US. I have to sort of preface this in my answer because it will not just influence the legal side, but also I personally view this and professionally, as that is what has sort of shaped my perception. That being said, on one hand, I do very much support the text and data mining decision exceptions for research and those and similar kind of instances, and I think that those should not cause a problem. And I also think that in principle, I think it is good to have open access materials in large language models, because currently there's a lot of really poor content in there. So I'm not sure if anyone kept an eye on Google doing sort of the answer suggestions, which took a lot of information from Reddit. And I'm not sure if anyone here has been on Reddit, if I'm the only young person who's on Reddit here. But Reddit is a bit of a cesspit, and I find it quite enjoyable in my free time to see the worst that the internet has to offer me and feel good about myself and my life choices. But when I'm doing work and research, it's the last thing I want. I don't want the opinions of someone who might be called Mr. Big Sausage 69, and that is genuinely the kind of username you find on Reddit. That is not the opinion I want in my scholarly comments. That is not someone I want to be including in my research and its reliability. So on one hand, I think it is good to have high quality inputs in these language models because it can actually improve them and kind of take out some of the not so good quality work. So that is on one hand a potential positive. I do think it needs to be informed consent. We need to be open, transparent and honest about this, and people need to have a choice, because I feel like a lot of the discussion and I think resistance is about there's a lack of choice and transparency, the fact that you might not know if your data has been taken and that you have no control over it. And I think that is what upsets people. And I think it's similar why we have a lot of these open access initiatives in the first place, is because I know a lot of researchers felt a sense of powerlessness over the materials they produced, that they might have worked very hard on something and published it and not been able to maintain control or rights over it. And I feel like there's a very similar risk with some of these LLMs, that it might be taken and you have no control over it yourself. It might be something you've worked hard on and it is now being used commercially by someone else and you will never see any return on that. And that is partially an inherent risk of research, but it is doing it again, and I think it is kind of hitting on a very existing, very sore spot, and I think rightfully so. I too am quite frustrated by this. But again, I feel like having on one hand the robot text files and making sure they are respected and enforceable, I think be really good. I think in the longer future, it might actually be good to have potentially an extension of existing CC BY licenses where we can say, I mean, CC BY itself might always just be open as long as it follows the general rules. We might say this one is accepted, this data set, for example, is explicitly marked as safe for text and data mining. We are happy for this to be used in large language models. I feel like especially as we move towards open data more, I think it would be good that if we have licenses that specify explicitly this is fine, I as a producer of this data, of this text, have said you are allowed to use this for your large language models, you know, given you're not doing crimes with it. That'd be very nice if we could do that. I think that is the main part. I think also as we move forward, I would hope that we start seeing more data and model statements, or cards as we call them, which are these sort of descriptions of what is this model, what is this data, what is in it, can we be transparent and honest about it, can we actually respect the buy part of CC BY, because on one hand it might be open access, but that buy part is in fact important. You have to attribute where you found something, I think, and obviously there's some legalities around it when you do and don't, and how much influence it has had, and also what is a derivative? At what point have you used a text as a derivative? Have you created a derivative? Say you have summarized a text, but you have changed it absolutely beyond recognition, and you're still attributing it to the original author. Is or isn't that a derivative? Have you violated a CC by ND? And that is the point where I would have to hand over to someone like Jonathan and go, I suspect there might be something here. I don't know. I am not an expert. I don't know the jurisprudence on this. And I think that's, kind of showcasing the sort of both joint nature, sort of interdisciplinary nature of this. But I think it is important that we think about, not just when we think about training and testing data, that there are different types of data that LLMs use. So I think if you saw me growing my pen just now, I was always had to draw something because I can't do this in words. So we have like what we call the training data, which is this big pool that the LLM is kind of built on. That is kind of the very fundamental thing that makes it being able to speak it on a set language. And then if you have like the little bit here, which is like the fine tuning data, and that is also just teaching this model, it's like a more specific skill. And I know there's like more specialized GPTs, for example, like specialized large language models work like that. And whether you are included in one or the other is quite meaningful. Is it training, testing, fine-tuning data? Because say I am building a medical model and I need fine-tuning data for health sciences, and I approach researchers and say, can I use your data to fine-tune a model for health research? I feel like they are more likely to say yes, but if I'm just going to scrape all of it to build a massive model, they might say no. And I think that is, again, where that transparency and literacy comes in, and that openness, and also understanding different uses of data. And I think having licenses that can accurately reflect what we want and don't want doing. And whilst legally it might be fine across the board, I feel like ethically it would be good if we can do that, even if only in our responsibility or social responsibility to each other as researchers.
Yeah, and I think it's, at the very least, what's clear is that we've got some work to do to make sure that we understand how those two things relate, in the sense, the way that Jonathan was describing, that the rules are getting relatively clear now, but how does that relate back to a CC license, let's say, and what does an author expect once they set a certain license, and how the reuse works and things like that. That still feels to me quite an open space, but maybe I'm wrong. I'm not an expert on that, but it feels, that balance between the rules and actually your intention of what you're hoping people will do if you don't understand that rules as well as, that the legal experts would do.
Yeah,
but
I think, just to maybe come in again, I think that is kind of, it's you have the rules, but then the following, I think that will be tricky. And I think that will take us time, and we're going to just have to, I think, collaborate on that and look to others in the sector and see what happens. I mean, Jonathan, correct me if I'm wrong, I feel like it's like law and jurisprudence. It's, you have the law and now you need to start applying it and making your decisions. And that's always the tricky but fun part, in my opinion. I think it sounds really difficult and quite complicated, but I think it's also fun and challenging. It's what innovation and learning is at the end of the day. It's, maybe just me being young and hope, but it is what I signed up for. It wouldn't be what it was if it wasn't challenging.
Yeah, I think also what's happened here though is that OpenAI sort of released ChatGPT on the world before a lot of things were figured out, not only on the legal side, but on the technical side, frankly, right? And so, the problem with hallucinations and the problems with memorization. I mean, conceivably, if they had waited a year, right, or 2 years, those problems would have been minimized. And I think some of the legal problems could also have been, thought through, or even this issue about the more granular bot exclusion headers, allowing search but not scraping for training. But they made a sort of a business decision. They wanted to be first to market. They wanted to, they unleashed ChatGPT on the world before, and everyone was kind of flabbergasted, right? That it was as good as it was. No one, I'm sure, well, Siobhan may have expected it, but the rest of us didn't. And, but maybe it was just too early. And if they had waited a year, I mean, Google certainly wasn't ready, right? And we know Microsoft wasn't ready. So everyone's kind of rushing to catch up, and everyone's releasing products on the market before they're really ready. before all the issues are, before they prepare people and think things through, like this Creative Commons thing. It's as Sharon said, it's not hard to fix. I mean, right? You just tinker with the license a little bit, and problem solved. And then you have the retroactive problem, but most people aren't going to do anything about it. Or you sort of say, well, as long as it's kind of clear going forward, that's probably good enough. But again, I think a business decision was made that then sort of thrust everything upon us.
Mm-hmm. Okay. Conscious of time, and I'd like to just touch on, maybe just for the last 15 minutes, maybe we move now to talk about the output side of things. So here we're talking about how, rather than thinking about how things might be used, scholarly communication might be used to train large language models, thinking now about the issue around how the outputs of large language models could be used in future scientific communications or articles, let's say, of that note. I think where the right place to start is here. I mean, I think Jonathan, perhaps you already clarified, I think, that the question really is around infringement from a legal perspective, and whether they are infringing previously used material, and whether you have the ability to put things under copyright once you have incorporated something that's come out of a large language model, as far as I understood it, I think. I mean, is that the main scope of the problem? Is that reasonably well defined at the moment, or is there still a lot more work to be done there than there was on, let's say, the input side of things?
No, I think that it's that pretty much summarizes the problem, and we have a lot of existing case law in the United States. That's how we would look at it and say, we have precedents to help us think through whether the work, whether the output is substantially similar in protected expression to an existing work that is out there. But as I said, it's just really hard. I mean, that case law is very messy, and it's very case specific. We have the one issue here, the one wrinkle that's going to be on top of that we really will need to sort through is and Siobhan alluded to this, it's the memorization problem, that even though supposedly no work is stored inside the large language model, that just because it sees the Mario Brothers, or it sees there's a lot of inputs of the Mario Brothers, that it doesn't it doesn't have a picture of the Mario Brothers stored inside the machine anywhere. But then if you, as a user prompt, you put, I would like to see a picture of an Italian plumber, out comes the Mario Brothers, right? And it looks identical to them, or very similar to the Mario Brothers. Now Siobhan will be able to explain why that happens, but that it's not really being memorized, but it's sort of being memorized because of all the predictive nature and all of the things, all the images that have been seen, and all the fact that you do have a zillion pictures of the Mario Brothers on the internet, and especially in Reddit, I guess. As a result, so then that makes this whole, even though that's just an interesting added wrinkle to this substantial similarity problem about whether and the liability. And then it's a question of, to what extent, when I put in my prompt, Italian plumbers, was I trying to get the Mario Brothers? And to what extent, are there filters that the chatbots can build in, and the LLM, the AI firms can build in to prevent an output of the Mario Brothers? But those are, some of the issues that need to be sorted out.
But it raises, I guess, the technical challenge. And Christine, I wonder if we might just come to you next, thinking about, some of the points we were just talking there about the outputs, and, how much as someone who is, utilizing large language models and providing that as a service to people, do you have to think about those outputs and some of the rules around how the outputs might be used and how you control how specifically your outputs might be? I'm wondering how much of a consideration that is for you, or whether you see that as outside of the responsibility of where, from a technical perspective, if that makes sense.
I mean, I would certainly not say that's outside our responsibility. I mean, what output we are bringing with any tools we are building is certainly our responsibility. I think you will find that any tools that are out there has a sort of disclaimer to say, you know, that it's not 100% accurate, or it doesn't guarantee that it's 100% accurate what you get out of it. I think we didn't really touch here on any of the ways we can have to base the content on things we are indexing outside training. So we talked a lot about training, but we're using, for example, for some of the tools in architecture, which we will augmented generation, where we do use a pre-trained large language model such as GPT 3.5 or 4 or whatever. But we are running it in a way that we are checking for documents that we are indexing that could answer a user question. And then we're sending this as context to the large language model, and the large language model is basing the answer on that input. Now, that's not perfect, because sometimes you have also an overlap between what's coming from the large language model and what's coming from the content, but it works actually pretty well. So we're using the language capabilities from the large language models, but we're using the facts and information that is coming from our documents, for example, from, you know, a discovery index or a database or that sort of thing. And the advantage here is also that you have a clear source. So you can say, you know, this is coming from this and this source. You have clear attribution for the author, and the source can also be checked because it's very transparent. So that solves a lot of these issues. I wouldn't say it's 100%, it's not, but it's pretty good. And then there are other ways, you know, it's if you provide tools for any sort of, let's say we're providing tools for metadata creation or metadata enrichment, you have the human who is sitting there at the beginning of the process, and you have the human who's sitting at the end of the process and is actually confirming that's okay or that's not okay. And that's possible, you know, in our arena. I would also say that, and that's getting back to the rights issues, you know, we have the full text of, for example, articles or books or other material, and then we also have the abstracts, which are sometimes, I think, legally part of the full text, sometimes not. And that's also another area which is quite hard. We're not even using that for training or anything, but, you know, using it in general. And what you can do if you use an architecture like the RUG architecture is to give people the option to opt out. And that's particularly for publishers or content providers who really don't want to participate in that sort of service. So there are options to do that, especially in that sort of architecture. And I'm sure there are other technologies coming up, you know, offering similar things. But we have to obviously, you know, comply to agreements and respect agreements that exist with publishers. We cannot just train anything or use anything with generative AI.
Mm-hmm. I think that's interesting, because we kind of separated the discussion thinking about it in a legal perspective from the inputs and the outputs. But I think what you're describing there is that you use a lot of the inputs to resolve some of the outputs issue. It's interconnected everywhere, and I think there's a kind of like a view where a really basic view where you just think, well, everything's just being harvested and everything's being spat out and there's no sort of rules around that. Whereas actually, you know, there's lots of techniques that can be used to make sure that those rules are being applied. And it sounds like the rules are and the laws that should define what happens are, you know, taking considerable strides forward, even if not quite as fast as the development of large language models themselves, which, let's face it, has been kind of astronomical. I'm always pleased to see Fran, but means it's the end of our conversation. I'm surprised how quickly we went through that. We had at least probably 2 other topics that we could have happily covered, but I think, you know, we also have to say we're covering one of probably the biggest topics that we have to discuss at the moment.
We just have a very interesting question. I don't know if we have like 2 minutes to answer. I think Jonathan and probably Christine might be able to give their point of view on this. This person asks, I understand the clear analogy between TDM and AI and the references to Article 3 and 4 by Jonathan, but isn't it the case that some AI can be done without text and data mining, and some AI companies are arguing that there is no copying at all? Should we be dealing with AI and TDM as two separate things?
Well, this actually might be more, well, or Siobhan even, it might be able to better explain that. I mean, at least my understanding is as the current technology is working, you know, and the definitions of text and data mining, you know, the existing technology would all be sort of within the scope of Articles 3 and 4. Again, you know, the bigger issue is is it for scientific research? But you know, again, this is ultimately more of a technological question, and certainly in the future, that would be, you know, Siobhan and Christine would be better able to answer that.
Okay, Christine, Siobhan, do you want to add?
I mean, you know, they're just very different forms of AI, also in relation of, you know, what you do with text mining or what you're even mining and what you're even using for training. So it's a little bit of a very general question. I mean, there are forms of AI which you don't use text mining for that. But if you use a large language model, then this is always trained on some sort of data, regardless of that is based on text mining or not text mining, but that involves text mining, I think, in most cases. So yeah.
Yeah, and the definition of text and data mining in the directive talks about computational analysis, which is more similar. So that's why it's all. And then you have the added issue, of course, is that every you have the directive, right? But then it's been implemented. Every member state has to implement it, and the way they're implementing it could be slightly different, and they might have their own definitions. So that's where, you know, this can become, you know, it's easy to say, oh, it's all the same, but then it could start becoming very different.
Okay, thank you. Well, we have some more comments, but I think I will share it with our speakers later. And obviously, we also have some other questions, but I will make sure that we can share it with the speakers. And if they are willing and able, they might be able to write to us and reply in writing, so that we can put it together in a post that you can be able to read afterwards. So I think we are at the end. Thank you all for attending today's event. I hope you enjoyed it and have learned something new. A lot of information shared with us today. So thank you again to our speakers and to Chris, our moderator. Please remember to let us know your topics of interest for our next event, and if you'd like to be one of our next panelists in the survey that you will receive via email later on today. And don't forget to register to stay up to date with future Karger events. Thank you all so much, and see you next time.
Thanks,
Thank you very much.